All right, today we've got a wild one for you. We're diving into a high-stakes story about tech, corporate backstabbing, and a courtroom drama that came with a nine-figure price tag. And the craziest part? It all started with a few seemingly harmless chats with an AI. Let's jump right in. Take a second and just look at this number. That's 370 billion Korean won. In US dollars, we're talking about roughly 270 million bucks. Now, that's not a company's revenue or its valuation. Nope. That's the size of a legal judgment against a massive gaming company. And this whole disaster traces back to a few conversations with a chatbot. So, that's the billion-dollar question, isn't it? How on earth does a simple chatbot conversation end up costing a company a fortune? Today, we're going to break down exactly how a series of prompts typed into a chat window became the smoking gun in a huge lawsuit, and what that means for every single leader using AI right now. We're actually going to start at the end of the story with the verdict itself, because to really get the lesson here, you have to see the catastrophic outcome of this legal war between the gaming giant Krafton and the former execs of a studio they bought.
And listen to this. These are the judge's own words from the ruling. The court basically said the CEO used an AI chatbot to cook up a scheme to fire his top people under false pretenses. And why? All to get out of paying a massive bonus. Just think about that. The key piece of evidence wasn't some secret memo or a leaked email. It was the CEO's chat history with an AI. Unbelievable.
So, how did it deal that everyone celebrated go so horribly wrong? To understand what was going through the CEO's head, we've got to rewind the clock. Let's go back to what started out as a really brilliant business move. Okay, this timeline really lays out the whole story. In 2021, Krafton buys this superstar studio. It's a great deal, but fast forward to May 2025, and they get a bit of a shock. Their own forecasts show that a bonus they promised is about to trigger for over $200 million. And what happens just 2 months later? Boom, the top 3 executives are fired. The court saw right through it, calling it what it was, a flimsy excuse to dodge a massive payment.
So this is the turning point. The CEO is staring down this gigantic 9-figure payout. He has a choice. Call the lawyers or try something else. He chose to brainstorm with an AI. And that single decision is what brought the whole house of cards down.
Now this part is just fascinating. The CEO's own human advisors, his lawyers, told him flat out, this is a terrible idea. Firing them won't get you out of the bonus, and it's going to be a legal and PR nightmare. So then he goes to ChatGPT. And at first, the AI basically says the same thing. It advised him to be cautious. But he didn't stop there. He didn't want cautious advice. So instead, he starts nudging the AI, asking it leading questions, essentially coaching it until it gave him the answer he wanted to hear. The AI then coughed up a whole hostile strategy document. So what did the CEO do? He created a secret team, codenamed Project X, and followed that AI-generated playbook to the letter. Okay, so the big question is, how did these supposedly private brainstorming sessions with a chatbot end up as the star evidence in a public trial? Well, the answer comes down to a fundamental rule of US law that, let's just say, a lot of executives are learning about the hard way. It's a little process called e-discovery, and here's what it means in plain English. In a US lawsuit, almost nothing you do digitally is off limits. The other side can demand all of it. Your emails, your texts, your Slack messages, it's all fair game. And if you try to hide or delete that data, you can lose the case on the spot.
And this was the fatal error. The CEO didn't just have these chats with the AI. He shared them. He copy-pasted the AI's hostile strategy into Slack and email. The second he hit send, his private thought experiment became an official, discoverable company record, and you better believe it became Exhibit A for the other side's lawyers. It was proof of his intent.
This case puts a giant spotlight on a huge legal blind spot for anyone in leadership who's using AI. It all boils down to one critical legal idea: privilege. And understanding this is the key to not making the same multi-million-dollar mistake. Here's the legal principle in a nutshell. When you talk to your lawyer about sensitive strategy, that's protected by attorney-client privilege. It is confidential. It is shielded. But when you have that exact same conversation with an AI chatbot, there is no privilege. Zero. An AI is just a tool, not a lawyer. And your conversation? It's just data. Discoverable data that can and will be used against you. And don't think for a second this is some fluke. We're seeing a clear trend here.
Just a few months back, a federal court in New York came to the exact same conclusion in a totally different case. The judge's reasoning was crystal clear. An attorney-client relationship does not and cannot exist with a chatbot. The legal system is drawing a very hard line in the sand.
So what does all this mean for you? How can your team use these incredible AI tools without walking straight into a legal minefield? Well, this case gives us a brand new set of rules for any leader using AI. Okay, here are the new rules of the road. First, and this is the big one, assume everything you type into a public AI could be read aloud in a courtroom one day. Second, treat everything an AI spits out as a rough first draft, not a secret strategy. Third, for anything remotely sensitive, we're talking M&A, HR problems, legal questions, just don't use public AI, period. Go talk to a human expert who has privilege. And finally, you need a clear written AI usage policy for your entire company, like yesterday.
You know, law firms are already scrambling to adapt. Some are now telling their clients, hey, if you absolutely must use AI for something related to a legal case, start every single prompt with this exact phrase. They're trying to wrap the AI's work under the protective umbrella of their legal guidance. It's a whole new world, but it just shows you how seriously the legal community is taking this. Which brings us right to our final parting thought. The Crafton case is a cautionary tale written in blinking neon lights. AI is an absolutely incredible tool. It can be a massive asset, but if it's used carelessly on sensitive topics, it can turn into a legal time bomb. So you really have to ask yourself, right now in your organization, is your team's AI use an asset, or is it a future lawsuit just waiting to be discovered?